All right.
Thank you, everybody, for your patience. We're ready to get started now. And it's a real honor to introduce Joshua Walker, who's the author of On Legal AI, and who has had a career that makes him one of the pioneers in this legal tech space. He was the co-founder both of Codex and Lex Machina, Codex being the Stanford equivalent to the Berkeley Klein Center. I think that's a fair characterization. Lex Machina being one of the pioneering legal tech companies. I won't take up any more of your time. Thank you so much for coming. Thank you all for being here. You have the floor.
Great, thank you so much. And I do have a deck, which I'm happy to share with you guys, but I'd rather just talk and take questions. Feel free to ask me any questions anytime. So that's the point of this. This is, again, thanks for having me here as well. This is kind of a tale of three cities. The first being Cambridge. I think about several hundred feet in that direction. I'm not quite sure. It was near Langdell, where the story begins, of legal AI. The other city was Palo Alto, and probably the third city is Chicago. So what I'd like to do is probably walk through what happened over the last, I would say, since 1995 through today. And you can use those little dots, if you will, from these little stories to project what might happen in the next 5 to 10 years. Because you're at flux in the legal profession, whether you want to practice M&A, corporate law, litigation, public interest law, prosecution of either kind, IP or criminal, you're in a state of flux right now. And all the old adages that people told me about being coming out of a top law school in '02 or so, they certainly didn't apply then, and they even more certainly don't apply now. A lot of things have changed, and being dynamic and listening to some of the other things that are happening in technology are important. So about 1994, I was a Harvard College student, and I snuck into one of those talk to people who have done different careers day things with a bunch of HLS students, and no one noticed I was there. The person speaking was named Crystal Nix. Crystal Nix graduated, I'm not sure when, but she was really the point person for human rights at State. So Crystal was the legal counselor. I, at the time, had just come back from Bosnia for thesis research. You may not remember, but in 93, 94, there were an enormous number of horrific crimes that were committed in Bosnia and Herzegovina. Rape camps, genocide, crimes of humanity by both sides. And I was trying to get a job. And so for a year, I bugged this poor person at State. And she said, finally, you've annoyed me enough. We don't have a job in Bosnia, but Rwanda, the genocide which had happened while I was in Bosnia. And then everyone said, oh, whatever we do, we like Bosnia, we're not going to Rwanda. We have a job there. And I said, I would love to go. And what happened is, and this is really about legal AI, believe it or not, and it actually really goes to corporate law practice and everything else if you're more interested in that. But what happened is we went to Kigali, Rwanda, a group of us, mainly sort of AUSAs, other attorneys, FBI vets, things like that. And we were supposed to have a database, right? It was a prosecution operation. We had millions and millions of files, which at that time was a lot of data, and a very, very opaque criminal enterprise, right? Very, very included, one of the more hard to interpret criminal conspiracies in history, really, given the scope of the crimes and how hard it was to piece together hard evidence against a lot of the perps. And the database they spent years building and millions of dollars building didn't work. So I was having my mother send me legal pads from Canada, and the great database of the prosecutor in Kigali was Microsoft Word. And we dumped in witness interviews and other stuff. And we started producing data from that. Despite the primitiveness of those conditions, that data system is probably the best legal informatics system I've ever seen implemented anywhere. And there was a simple reason for it. There was an isomorphism between the data set we were working with and what we were trying to do. We had essentially a dysfunctional new enterprise. We were starting a tribunal with not a lot of accessible resources. in a difficult place. We had prosecutors and attorneys from all over the world, from very different backgrounds and interests and skill sets. And we had a great coordinator. The guy I worked for was spectacular. He broke up the genocide into 21 different component parts. He assigned 2 investigators, typically one from Africa and one from somewhere else, right? So we mixed up folks really, really well. And then he assigned that, and then we put data together for each of those different components of the genocide. Thanks to him and a lot of others, they convicted, I think, every single one of our targets was convicted. Again, not a perfect place, a difficult environment, but that to me is the beginning of legal informatics. It's the same story in terms of the analytics, doing M&A, doing PE deals. It's really all the same thing, technically, but that's the beginning of legal AI for me, and why it's worth talking about and doing this stuff. If we had a much more sophisticated system, we probably could have gotten answers in analytics faster, but that's the beginning. Fast forward a little bit to Chicago. We had a lot of great personalities in Chicago. Cass Sunstein was there teaching behavioral economics. He was right when Kahneman was getting his Nobel Prize, so I'm not going to say what nomination forms I saw on the copyright, the copying center floor of Chicago, but it was an exciting time for behavioral economics. Posner was there, President Obama was there. Really interesting space. Brilliant minds. The problem with Chicago, although it had this amazing math focus, the problem with Chicago was that while we had some of the greatest legal folks, there was a small c conservatism to what people wanted to do. When you walked around Palo Alto, you would literally bump into, Mark Zuckerberg at the time and others who wanted to change the world. And again, I'm not endorsing any particular view of the world right now or what anyone has done, but there is a sense, a distortion field there about what you can accomplish as a human. And that was not always present, despite the ability and skill sets of a lot of the folks students and others I met with in Chicago, in the CS department and elsewhere. In Palo Alto, people wanted to change the world. In Chicago, people did not want to change their lunch plans, quite literally. I think I convinced Argonne National Lab that we should do something and that we got an RA going, but it was very, very difficult. Went to Palo Alto. I was a first year at Skadden after the crash. All my friends fled to safe jobs at Lehman Brothers in Chicago and New York, often, unfortunately, literally, or other firms, right? And I was bored out of my mind. Everything we were doing, was $1 billion mistake if you messed up the signature page for an M&A deal. I had a child at the time, so was also supporting a family. So it was very important what we were doing. We were doing the 10K for Yahoo, right, which was the internet behemoth of the day. Not to date myself too horribly, but it was the behemoth, right, and we were doing all their corporate work. But I was bored out of my mind. I said, robots should be doing this. I was trying to teach myself Lisp so I could apply to the Media Lab down the road, down that road. And while I was doing that, someone from Stanford finally came through and said, hey, why don't you come talk to us? And bless you, the goal, that conversation became something called the Computational Law Laboratory and Codex eventually. But it was a struggle. And I remember the other first Harvard connection was there was a Berkman Klein Center and Stanford CIS event that we had that summer. There was like a summer fest, right? It was almost like a Swedish kind of festival kind of atmosphere with the two groups in Palo Alto. And I pitched a very famous law professor, I'm not going to say from where, and I heard back from my HLS friend afterwards, and I said, what did he think about my idea of mixing law and computer science? And she just wrote back, well, one word. Do you have the, here we go. It's a great word. So that was the reality back in 2001, 2002, 2003. When we originally pitched Codex to Stanford Law School, it came out as robot law, and no one wanted to touch it. So if you're doing policy around internet, if you're doing internet, antitrust compliance for internet companies or social. I mean, it's a huge field, very active. It's a job for life, I suspect, or at least this administration's life. So, the idea of applying computer science to law was pretty weird at the time. It seems pretty normal, actually, but at the time it was very strange. But eventually we got through. There was another woman named Peggy Radin, who went out to Michigan afterwards, but she was also instrumental. Mark Lemley was gracious enough to sponsor us, and we had a logic person at the computer science department. Fast forward again, we had a small, also Cambridge story-connected company at the law firm we were working at called thefacebook.com. Very small, had a couple 100,000 users. And this is all public information, by the way. Anything I'm telling you is in DMAS court, also down the road. Not technically in Cambridge, but close. And we were defending these folks, and fortunately we had some success in knocking out claims. All of that's public. We filed some counterclaims in Santa Clara on a hacking claim in that case. Again, that's all public information. But I saw what these people were doing, and I said to myself, I am such a loser. What am I doing with my life? I mean, these people are changing the world and having an enormous impact through technology. I love to write and write really good prose that is legally efficacious, but what is the impact in terms of scale, really? I'm not affecting millions of people. It's deals and it's litigation and what have you. And so in this context, one of my friends from Codex, Roland Vogel, who's one of the co-founders there, and he runs it, again, it's kind of like CIS, Berkeley Klein, but it's also the converse as well. But so Roland was there and he said, hey, we're trying to build this database, on empirical stuff. Would you be interested in, if you know anyone, it was an invite. It was like, if you know anyone, let me know. And I came back and said, not interested. A, sounds boring. B, it's going to fail, right? It's doomed. Why was it doomed? So again, one of the most top professors in the world for IP had founded this thing. They'd raised commitments of lots of millions of dollars from a lot of big companies across the diverse scale of intellectual property. By the way, how many are interested in IP in the audience? IP, corporate? Okay, human rights, public policy. Good, so everything. So I've got to cover all these bases. Hopefully we'll cover all these bases and not too stochastically. There were no data at the time, no good data in the United States about intellectual property cases. So trillions of dollars of value at risk, and no one knew really how many patent lawsuits there were. We roughly knew. We certainly did not know what the outcomes of those cases were. And if you can imagine being a factory owner, but instead of a factory owner, you're John Roberts, right? Or you're the Supreme Court and you're running the administrative office of the US courts. You have no idea what the outcomes of your factory are, what it's taking in, what it's putting out. You have some rough idea, but there's no real quantitative or empirical data that you can rely on to determine it. If you are a general counsel of Apple or of Google or of any large company, it was very, very difficult to know at any one time, A, how many cases you had, even in the IP space, or B, what the risk was associated with that. And right now, by the way, I happen to be the chief product officer for a company called Aon. They're an insurance company. Who could have predicted I'd be working for an insurance company? But it's exactly the same story of analytics and risk that began here a few hundred meters away and continues now. So I look back and I said, I'm such a loser, and this is kind of a good database project, right? It's not as important as the ICTR was. Convicting, Rwandan war criminals was an honor to be involved in any way, even as a super junior person in that. But it could impact huge numbers of people, and economically it was enormously important. So I said, I'm such a loser, I should do this, took a giant pay cut, huge risk, and worked in the basement of Stanford for 2 years, reading, every patent trial, for 10, 20 years, what have you. Most of the SJs, all the appeals, and we eventually scaled up that team. But it was sitting in the basement coding things. And then we needed computer science. So we had no computer scientists that, with the technologies we needed really to do this project. The reason the project was doomed to fail was twofold. First of all, the closest thing we had to this was the securities class action clearinghouse. By the way, I'm sure these terms are pretty, how many 1Ls in here, by the way? Okay, 1Ls, 2Ls, got it. 3Ls, another around. Got it, okay, great. So let me know if you, feel free to stop me if at any time I'm using something that I need to dive into or explain. Essays in summary judgment, I'm sure you got that one cold. So the reason it was doomed, the closest thing we had to the securities class action clearinghouse, there were about 220 securities class action cases per year at the time. They're all public. The settlements are public. They have to be public. They're class actions, right? Patent, all the settlements are secret. Trade secret, there's no data at all. It was all state at the time. So it was this weird data myopia thing. And for every one of these cases, you might have a patent case with 9,000 different docket events, any one of which could be a 5 to 1,000 page document thing. And you'd be dead by the time you came up with any useful data with even a large team doing this manually. So we needed some humans to help us build the machines that were going to help do the auto coding, which were not doing anything glamorous. They were just automating me sitting in the basement, coding something as a summary judgment or as a something else, or a Markman hearing or as a something else, right, in the patent world. So I walked across campus and talked to a guy named Chris Manning. Chris, I was connected to also through Cambridge, right, through another Harvard College friend who knew a guy named Andrew Ng. I don't know if you know Andrew Ng. Andrew was the chief scientist of Baidu, co-founded Coursera, is now way more, so famous that he's difficult to reach sometimes, but amazing person. And he said, you should talk to Chris Manning, he does natural language processing. Chris said, gets bombarded by every big company in the world all the time. He said, no, please go away, I'm busy, thank you very much. Very politely in his Australian accent. I went back a second time and I said, look, this is really important for the country. If we do this for patent, we can also do this for other things. And computer scientists and engineers as well at the time hated patents. Hated patents. And a lot of them still do, and it's a reasonable perspective, right? Hated patents. They don't want to be told or restricted about what kind of code they can write or implement. So that was part of it. I said, look, patents really important, and to make the system more normalized and rational, you need some data, some empirical data about these types of things, right? He said, go away, please, I'm busy, I've got 12 PhD students and yada yada. Went back a third time and I said, the way that lawyers write is uniquely accessible to you. You writing a brief or a contract or an indictment or even something for the State Department, whatever it is, that language you are using is much more formal and structured, as you probably know, than, even though the life of the law is not all logic, it is much more structured and accessible to computer science systems than other types of things. So I said, it's really important and you can get better results from this as opposed to other natural language corpuses. He said, really, go away or I'll call the cops. So then I hired one of his top students, who was a Russian physicist, physics Olympiad winner, a brilliant, brilliant person, went back and he said, yes, finally. And when we got Chris, we also got Andrew Ng also helped us with the machine learning side of what we're doing. So we started automating this thing. It was Stanford, so we spun it out, of course, because that's what Stanford always does. But in the charter for the organization, we had 3 things that we did. We were required by law to give this away free to judges, the most advanced system, to all academics, to all students for free, ad infinitum, right? That was the charter, and that was what we implemented. A lot of other stories in this that I'm not going to bore you with today, but essentially, it was a miracle this thing survived. There were 7 or 8 things that could have killed us, from bureaucracy to politics to the courts themselves. Not every judicial district wants to be illuminated in the way that they are right now, in my view. Many of them do. And we had, for instance, to give you a taste, we had a large fight over initially whether we could access certain federal docket information. If it's a public information that were on PACER, the system that is used for the court electronic filings throughout the United States and in all districts. We had to brief the issue for Chief Judge Walker, and Von Walker decided in our favor. So because of that, we had access to everything initially when we were at Stanford. And when Roberts heard about it, when it became commercial, it became harder, right, to collaborate as productively with the judiciary. But we were required by law to give access. What Von Walker did was actually very brave. Von Walker, I don't know if you know this, but he's the person who did the first gay marriage district court opinion. So in my view, he's a hero in a lot of different ways. But this was making his life easier as the chief judge by enabling him to manage his IP docket was better. Especially if they didn't like patent cases. They sucked up so much time. If you're a federal judge, which some of you will become, and you hate patent cases, you want to focus on common law and crim, having something to manage that activity and help illuminate different ways of interpreting patents is very helpful to you. So that kind of mechanical operational support was important, even to help them do other things. Anyway, so that was Lex Machina. We sold it I didn't sell it. There was a great guy named Josh Becker, who was also our CEO a little later on. I went back to practice. I liked helping people with, getting deals done. And the tool was really great, but it was solving a problem that we had now solved to some extent anyway. And it's never over, right? These AI systems, these classification systems, you're always trying to improve them and predict them. The dangers of these systems are that people think you can predict the outcomes of cases with them. As soon as a judge knows that you think you know what her decision is going to be, it's going to change her decision, right? And they see the same data on you that you see on them. So it's a bi-directional elimination in these cases. Anyway, when we were in the basement about 2006, we had, please feel free to get up and go. I know you guys have classes and fun things to go to. When we were in the basement about 2006, we were thinking that eventually someone in the insurance world would start to be able to use this data and to be able to take it and offer insurance policies on it. That person is someone I'm working with today. Also a Harvard math undergrad. I work with that person today. So now there's data on all these cases. You can manage the risk, if you will, and you can price it. And because you can price it, and because you know what the reality is for certain types of patent cases and others, you can now lend against that. It's like an asset, like a house. Whereas before it was really very, very fuzzy to determine what the value of a piece of IP was. Now it is much easier to do that. And they can finally insure against the theft of actual, not just cyber theft, but if you lose your world-class trade secret crown jewel algorithms, that kind of event can be insured for the data itself. So again, taking IP out of chaos in terms of the data and moving into something that we can actually see what's going on. And the courts have really changed how they handle things. Hopefully having the data has helped the White House, has helped the Supreme Court, and has helped others become more rational about how we manage these vast economic systems. Where we failed Von Walker, for instance, is he gave us access to the habeas applications. So habeas corpus applications, they get thousands and thousands of these things per year. And if you are a federal clerk, one of the first things you're going to be doing is handling these things. There are a lot of them. And there are many, many that lack merit, and there are many that do have merit. So very high risk. Someone could die if somebody makes a wrong decision. But there's a lot of stuff to get through. And you also have heavy opinions and patent cases to worry about, right? So how do you deal with that? Where we failed is we didn't have the resources to manage and analyze the habeas applications, to help people just figure out, where we were likely to see something of merit or not, or to at least help streamline the process of review for federal judicial clerks. So that is work that still needs to be done. And I saw time and time again in doing these types of projects, the most important projects for the US judiciary and the law were generally the ones that were least funded. And that is kind of terrifying. Compared to the UK, for instance, we're really underfunded in the judiciary and the AO, administrative office. And that's because Congress controls the budget. Congress does not always love federal judiciary members who, strike down their laws. So that's the really dumbed down, that's kind of my very glib version of why budgeting for really important judicial work is not there while we don't have the infrastructure. Who's gonna fill the gap? Harvard, Stanford, Chicago, every law school, every law student. You are the ones that have to fill the gap in the failure of the United States to properly fund its judicial infrastructure, if you will. And I'm not talking about judges. The judges, federal judges have all been universally brilliant. I haven't met, again, I don't want to overstate or again be too glib. It's not a problem with the quality of the people. It's technology, operations, infrastructure, chiefs of staff. Like, how do you fund those types of things and compete with Google or everyone else who's hiring folks like that in Massachusetts, California, and across the United States? So anyway, questions so far? I know that's a lot, but good. Yeah, go ahead.
It's a little bit out of my wheelhouse, so I'll try to make sure I'm saying things right. But on
your
point with how, being able to quantify the losses from intellectual property or patents and everything. I know the general discourse is that intellectual property and cybernetic property is hard to kind of retrofit into
yes.
property doctrine. So does this help just retrofit it back into how we currently analyze property, or is this still something that we can't really fit it even with this technology?
We do this now. I have a deck of 30 slides, which I will not get to. I can, but people want, but it's about how we can value intellectual property. So the vast majority of the value of public companies in the world it's 18 trillion of 23 trillion is intangibles. It's mostly IP. Know-how, it's data, it's all this stuff. And when you do, we did again, all public, we did the Dell take private, right? Really complicated private equity transaction. I worked with a phenomenal private equity lawyer at the time of Simpson Thatcher. And extremely complicated, but whether you can do a valuation of the intellectual property assets at the time is a complex question. Now we have the capability of doing that, right? You can actually look into it. I'll give you an example. At the time, the number of asserted patents in the United States were about 36,000. There's millions of them outstanding that are active, right? That is only a small subset, but there is a relation between every asserted patent, which again has to go through Rule 11, so it has to be reviewed by some human lawyer expert who says, this is a valid patent and it applies to something that is commercially valuable. So you can map the asserted patent or the set of asserted patents to every other type of patent. And I'll give you a very clear example. We found, Mark Lendley, John Allison, there's a bunch of papers out, I don't remember whether they're HLS or Duke Tech Law, but we found that if in this case of software, 95% of all software patents had one or more claims invalidated in a US patent lawsuit. 95% of them. Semiconductor, 33%. Takeaway, maybe we're not fantastic about patenting software in the United States right now. We have to go back to the drawing board. I'm not saying we're at the right level right now. I'm just saying we have to get better at it. Because whenever you see a new technology, it can be DNA, it can be CRISPR, which is also exploding in Cambridge and Berkeley and everywhere else, Shenzhen. That new thing, it means that there's a lag time between how we know how to propertize something, associate value and legal monopolies with them, and what we do. So there's a Cambrian explosion of patents, and then the judiciary maps it out and gets rid of it. What we wanted to do for the PTO is say, look, the judicial invalidation data, where something's invalidated or found to be, where there's an equitable conduct, for instance, that is quality control data for the patent office, for the admin. And you can see how we can do this with everything. EEOC complaints, right, OSHA, you can do this for anything. You can say, dear administrative federal body or state body, whatever it is, if you have the data, even start with Delaware, right, and go from there. dear administrative body, here's some data about what's happening in the courts. Maybe we should kind of reconfigure our grant systems so that we have less of this injustice and horror. Somewhere along the road, lawyers, liberal arts people like me, and I'm like the hardest core liberal arts person ever, which is ironic that we have a book called On Legal AI. But please, by the way, take a look at the book. It is a Harvard story, and allegedly there are some decent jokes in there. It's allegedly, right? But please take a look, because it's a story, it's empirical data about stuff that happened, and it enables you, right, as new graduates, to what the VCs in Silicon Valley always say is make new mistakes. You can learn from everything we did right or wrong, like that, and you can kind of leap ahead of where we were and solve the problems that we haven't solved yet. Habeas, right? Doing this for the ICTR. By the way, when I applied to the International Criminal Court after law school, I had I had Jetstone and I had the poser letter and whatever. It was great, except the ICC was not particularly fond of Americans at the time. There was a war almost politically between the International Criminal Court and the US administration over war crimes prosecution and universal jurisdiction. So, that's an example of, sometimes life has its own plans for you. Or in Yiddish, it's man plans, God laughs, which is another theme of the book, I suppose. So you can use that data and you can do a fallback. So you say, we don't need to grant something if we know it's going to get invalidated. Or if the judges are off, if we think that the judiciary is making a wrong interpretation of something, well, we can also say, you can change the law. So you go to Congress. So we went in, I'll give you an example. We went into DC one trip. I had a guy he had just graduated from high school, but just brilliant person. And we had our first hire, Samuel Wang, who had dropped out of Stanford to work on the project. It was the three of us, and we were all presenting, by the way. High school student, me. We hit the White House, OSDP. They went to the Senate by themselves. They went to Leahy by themselves. They did an amazing job. And then we talked to every single judicial clerk at the Federal Circuit, right, which is across the street from the White House kind of office. And that is the way democracy is supposed to work. That data should flow from one area to another. And you'll notice that story is not dependent on patent law. If patent law bores the tears out of you of no interest, the same thing could be done for criminal practice with the AUSAs, the USAs. We can do the exact same thing. But that data, that empirical data, needs to talk across these things. Other questions? Yeah.
So it seems to me like there might be something fundamentally different about looking at patent cases and using AI to kind of draw insights out of them versus building AI to help with habeas petitions. How do you personally approach the question of what margin of error, if any, is okay if there's a petition that a human would have flagged as having merit that the AI doesn't?
So there is zero margin for error in cases of life and death, right? What you do, though, but let me take it back. Let's go to the Rwanda tribunal. There's not just life and death. 1 million people have been slaughtered. And those were my clients. So the reason we needed data was to organize the data we had. We had witness testimonies and things like that. So if you're a prosecutor, you need to go to do a wheel chart, you need to do a conspiracy theory or whatever you want to do as your prosecution theme. You need data to build up that case. So the evidentiary side of the data is there. You can start to automatically organize the data here. Let me give you an example. You can probably auto-identify where someone is they could die within 24 hours. That gets routed to the human right away. It won't be perfect. It might be 98% perfect. But right now the system is, I have 10,000 habeas applications to review. Let's go through them linearly in time. No, somebody should jump the queue if there's a life and death issue. If a gang is about to kill someone within 48 hours, that has to go through much, much faster. But you have no way of routing that right now. So I would argue that in those cases, as I said, those cases need the technology more. But what you do, I'm going to call this user-oriented design, but it's life-oriented design in this case. If someone's life is at risk, and we think there might be some credibility to that, that jumps the queue. The system can help you do that and do the analysis faster. Did I answer your question at all? It's a profound question, but yeah. Other questions? Good, sure, yeah.
Thank you for the interesting talk. I have a general question for legal AI.
Yes.
See, I think, if we talk about whether we should have application for legal AI, there is a trust issue here.
Yes.
A lot of algorithm software like Compass now already applied in many states in the US.
Yes.
Apparently, in the Lumi's case, we see the judges don't know how to deal with this,
Yes.
the inner logic with the software. So because of the trade secret and also the copyright issue, apparently those software companies, they don't want to share their,
It's like the election companies
so
things,
how
yeah.
do you will this, how do you address this challenge if we want to, have some bright future of the legal AI?
So it is a beautiful question. It is not even a challenge, it's an acceptance. So my philosophy was assume all data are false until proven otherwise. We did not ask anyone, even for Lex Machina, to trust anything we said. We got them to the document signed by the judge. So, and we told them that. I mean, the TOU, which they are still using, which I drafted, it was in the basement of the law school, right? It literally was, I don't think it was a sub-basement, it was just a basement, but they're still using it. And it says, this stuff you can't trust this stuff. You have to rely on your own, just like case citing. It's the old story of the person loses their job because they relied on the head notes machine. They didn't actually check the sources to see whether the case was valid. We trust nothing. And the reason it worked was because we were so humble. The reason a lot of engineering-focused law applications have failed is because of arrogance. Not that they're arrogant people, it's just they think, it's just more data. It's not. They need you to lead the design of any of these things, because you can't trust any of them. Anyway, did I answer your question, or anyone else? Yeah, go ahead.
Legal education, as you all know, is notoriously doctrine-focused, particularly in one area. So talking back to what you said about the difference between Palo Alto and Chicago, what kind of strategies would you adopt? Would you recommend for law students to be more aware of those broken systems and what we can do about it? Yeah,
I mean, and it literally is. I'm not trying to say that it's all on you. It's just, we launched the company, we had Jerry Yang, who had invested in the company. Jerry's a brilliant investor. He invested in Google and Alibaba, right? And I said, we need 20 Stanfords in the United States, or whatever. And he said, there's not enough resources. I also asked the president of Stanford, who was also there, I said, you should focus on law and computer science. This should be an institutional priority. It's like a brilliant person, great entrepreneur. He said, lawyers don't get things done, quote, close quote. So of course I got into a debate, which is, again, the story of my career/life. But you need to drive institutional priorities that can focus on things like habeas, like First Amendment rights. There are a limited number of institutions that have the capability of merging the technical skills, the resources, getting the funding together. You do need all of those things, and it requires project management, sales. It requires an appreciation for math on your part. But you don't have to be a math expert. Again, I work with the math person who's right next to me. You have to be able to talk to people. And let me dive into that a bit. It was a professor named Herbert Kellman who was down at William James. Lovely human. His family escaped Vienna in 1939, I think 38, 39, right before the World War II and Anschluss. And he devoted his life to conflict mediation. And he said, look, some people are good at working on the corners and some of the quilt, and some people are the patches, some people are good at knitting them together. So in any organization that's doing legal AI, you need hardcore lawyers, right? She has to be, I found someone who was a lawyer who studied, fungus for her PhD thesis. She loved looking at the data and just sort of figuring out exactly what this type of entity was. And she did entity classification for us and was brilliant at it. So you need the people working on that quilt, you need to map it to mathematics. So I didn't have to understand computer science or really math. I had to know what graph theory was, and I had to be able to allocate it. And how did I learn about graph theory? I read history. I literally went into basements and I read about history of mathematicians, and it taught us how to map these things. One of the real failures that we've had in the last 200 years in the liberal arts and sciences is they've bifurcated. And that's really the theme of the book, is you have to start mapping, knitting together this kind of Renaissance theory of the hardcore liberal arts with the sciences, as Steve Jobs said. Anyway, I think we're starting to people got to move, but more questions? You're going to keep going?
Keep doing questions, or
Good.
do like one-on-one the last 5 minutes or something?
Yeah, sure, we can keep doing questions, it's fine.
So I have a question that is a little bit related to that about
Yeah.
how in Palo Alto especially, people are very good at working at the edges of the distribution, things that may materialize, may be more of a
Right. There is a craziness, it has to be limited craziness, and there is a hubris to Silicon Valley too, by the way. They don't care, human rights is not, is a hard time, but yes, that's absolutely right.
So I'm wondering actually, so we've talked a lot about things that, you know, are, we're kind of living in the realization of the distribution, right? Projects that you've already accomplished. Even with the things like the application of this technology to habeas, it seems like that's something where we kind of understand the mechanics of how it would work.
We could do
So our
it, we
research
could totally do it, yeah.
So my question is, can you talk a little bit about the things that you're hearing or things that you're planning in terms of new applications of AI to law, in terms of where you think that the discipline might be going?
Yeah, so again, that's in the book as well. There's 3 use cases. The main one of them is Lex Machina because it's deployed, people use it. I think partners and judges use it, which is awesome. It's a dream that these people, these top professionals are still using this machine. And it's managed to grow because it's scaled across the data sets. By the way, even if you don't know math, if you know enough economics, it's going to help you in habeas, in human rights, in corporate law, IP, whatever. I was appointed to a task force in California for the California Bar. It's we're a state organization, of course, state government. And the task force, I was a little more conservative. I think lawyers should lead this stuff. I think lawyers need to drive it. I've seen too much arrogance out of Silicon Valley to say that engineers should be telling people how to practice law or what to do from a legal perspective. It has to be you. But we have to be open-minded and adept enough to use that. So we're on this task force, and the task force recommended that we look at delivery of legal services to people, right? Because we serve about 2% of the legal need in California, of like family law. Most people are underrepresented. Family law, immigration law, it's a disaster, and folks come in on the need. There is a great groundswell of legal technology people. We're talking at NYU next week. There's a huge numbers of startups now. It wasn't the case at the time. At the time, we were radioactive. No VC wanted to talk to us. Now you could start a company and you could get funding, which is amazing. But it's just this bubble. We haven't crossed the chasm yet. And the reason I say that is when the task force released these recommendations, there were a lot of good critique, and we're a public body, so we have to do this. There was a lot of medieval scaremongering. And what they're saying is that, California's going to make Amazon replace all lawyers, or all the immigration law is going to be practiced by machines, and they're going to kill people. Like, it literally is that level of scaremongering. The bar has been asleep for 200 years, right? You have not used math efficaciously or operations research or realized that it's like surgeons running hospitals, right? We're word surgeons, but we need other people to do other things. Oftentimes, I asked the admissions director at Yale why I couldn't get into law school. She said, sometimes a strength is a flip side of a weakness. And it was a brilliant statement. We're really good word surgeons, but we're not good necessarily at operations or math or executing on these things. So you need other people. We have to do a better job at selling to lawyers, right? Partners at law firms who don't necessarily have an incentive to innovate, right? To clients, to others, to the bar, that we have to start adopting these tools. Because what is happening right now is people are worried about losing their jobs. There's no longer a safe job out, a safety net, just because of the degree anymore. I mean, I hired 7 furloughed people out of one law firm after the crash in 2008. 7. They were all from top schools. Some from here, some from elsewhere. I hired an unemployed Yale law grad, right? Shocking. So the reason that's happening is because we've been so uninnovative or unadaptive, if you will, or unusing these other things, that other professions are eating away at the legal profession. Contract review, right? Compliance, GDPR stuff. A lot of that is being led by consulting companies and accounting companies. And again, I'm not going to opine at all about what the legalities of that are. There's a band that they can work on. They're using AI. They're doing deals. They're funding startups. These people are really innovative. We have not been as innovative as the other service groups. And so, that's, I think, the next step in crossing the chasm is not just to build innovative things, it's to get other lawyers on board with what we're trying to do. Because there's a defensive shell thing happening as the market for a lot of junior or maybe not premier, folks that don't have great jobs out of law school. That market is shrinking for them, so it looks like the sky is falling, so they're getting more and more defensive about using technology. We have to show them that it can enhance the rule of law and what they're doing, not otherwise. To do that, they have to lead, and that means you have to lead. Other questions? Happy to go back to that too, yeah.
As I understand it, the point you were making earlier, you could effectively value intellectual property rights in a way that hadn't been previously done.
Yeah, and I'm going to say the caveat, because I'm a lawyer, caveat to that is it will never be perfect,
Sure.
Just like Lex Machina. We don't predict anything, we show the history, but it is radically improved.
Has the IRS shown any interest in that?
I can't speak about active cases. Some of our people at Aon are actively involved in IP valuation cases. I'll leave it at that. And it is a radical, massive change. Some of this has already changed because of, and there's also questions about offshoring. What kinds of intangibles can be offshored? You can value them correctly, they can be offshored. So there's massive economic benefits to that. But lawyers have to do the analysis, not consulting firms. You have to look at the merits of the qualitative data. Again, going back to your question, if you're arrogant about this, you will fail at it. You need you to do the qualitative analysis of the legal part of it so that the quants can then take that and operate on it. Again, you can rank something or code it or classify it, and then they can automate that. So I think there's a massive change coming. Did you have, were there other parts to your question, or?
I mean, it's tied into probably what you can't talk about, but just from the IRS's perspective, transfer pricing is a huge cost in the economy, and being able to move intangible rights, which are very difficult to actually price, it's very difficult for the IRS to accurately make assertions. And
yes.
There's a database that allows them to make at least prima facie assertions. I can see them being very interested, but I feel
like I said, it's useful to have judicial data, even for patent data, to correlate back to the other parts of the US government. So, and we see enormous interest in these types of data, not just from, say, the IRS or from EEOC, but also the White House is always, across every administration, is looking at this stuff. How do they do policy better? What is the Solicitor General arguing? So I think there's massive change coming. I'm not personally involved in any of those things, but there is a lot of, I think, more accurate analysis in the works, but it takes data, it takes a lot of humility to do that. And the more humility you have, the more accurate your data will be. Yeah, so it was a great question. There was another question up there too, I think. Yeah.
What are your thoughts on explainable AI and interpretive models in the context of legal AI?
The smartest person I know, he would never describe himself as the smartest person I know in this area. But the smartest person I know in this area says, you cannot reveal everything. Just, by the way, do you want to describe what that problem is, by the way, for everyone else?
So
explainability.
AI, or like a lot of the AI models, they don't actually, it's like a black box model, so you don't actually know what's happening, you just get the result. Whereas like explainable AI or interpretable models kind of give you either the distribution of the answers, possible answers, or it gives you more insight on how the AI models came up with this, the results. So I think in the context of legal AI, that could actually be related to her question, which is trusting the...
Yeah, and the answer goes back, the glib answer goes back to that answer, which is that we don't trust the AI, we trust the document with the judge's signature on it, and we're paranoid. What could go wrong that we don't have the right document, right? And even then, the TOU is we warn people, right? So there's multiple layers of checks. We don't trust the AI, we trust this is the artifact. We just help the user find the right order, right, in this case. The deeper answer I heard from my friend is that you can't dig it. So if you have a deep neural network, even the people that built that don't know why it decided that this is a cat and this is a dog. They don't know. It's a mathematical. You can't see into it very well. If you have 7 or 8 competing models, though, you have, if not sunlight, you have diversity. So if you have 7 or 8 different ways of analyzing something and they all say the same thing, that's a pretty good indication of something. It doesn't solve the explainability problem, but my answer for real life now AI applications is we don't trust the AI, we trust the document. It just helps us get to the right answer faster. Or it identifies this is what we should look at. At the end of the day, it takes someone looking at it. You're not going to indict someone based on an AI recommendation. It's going to help give you evidence, help look at success rates for certain types of claims. It's going to help manage. It's going to be like a dashboard. When we sold Lex Machina in 2008, when we were selling this thing, I didn't talk about data. What partner in a law firm wants to hear about data? We talked about history. We were quoting Santayana, right? And it was all about history. So that is a fundamental problem. I don't think we'll figure out explainability here, but competing models is one answer. For us, we trust nothing. Assume all data are false until proven otherwise. Other questions? Yeah.
Yeah, this is more like technicality question. So I probably apologize, I haven't read the book yet. So
yeah, please do. But on legal AI, yeah. Thank you.
Probably it's not convenient for you to release too much information.
No, please.
The how. I wonder. So far in the field, mostly when we use AI and machine learning to analyze the text,
yes.
we do frequency counting.
Yes.
Then group them into different words and
yes.
meaningful.
Yes.
Then compress the data.
Okay.
So you are saying using AI to analyze judicial data.
Yes.
Is that what you do, or you have even about something higher and analyzing the
yeah.
logic?
I can talk about this because we had to open source Lex Machina to get it out to get it to privatize it. So that is all. Some of that is open source. Of course, lots of patents and trade secrets after that. What you're doing. So, for instance, to identify a Markman order in a patent case. So again, 9,000 different things happening in a case, right? Any one of which could be 2 weeks of your life as an associate writing and drafting, and then the partner going back and forth with it, or you just doing it, right? If you go to Quinn, you're writing it, you're filing it, and you're doing all of it, right? So there's depending on what you do, massive complexity. For every item that is a Markman order, which is the judicial order interpreting the words of the patent, there are 200 other types of things that have the word Markman in them. So we had to invent our own language, and it was going back to your question, it was me sitting with the person in the basement, this time at the computer science building, right, the Gates building, where at Stanford, with the machine learning scientist, figuring out what were the features that would determine whether something was a true Markman order. The thing you have to remember about AI is it's a fingerprint. These things are not the same. They're not equivalent in any way. The legal state, the determinations I made about what was it, and I went up to experts and judges are, if anything, opinionated, as are clerks, and they will tell you if they think you're an idiot, right? So we had great data coming back to us to say, we think you're wrong about this, or we need this. This is the other type of thing. The only way that a lot of clerks had to get to find all the Markman orders in the United States was through Lex Machina, strangely enough, because that was such a hard problem. But we built a language. We said, this is what we're going to construe as a Markman order, right? If it's a magistrate judge's order, is it or is it not? Only under certain circumstances. So it was a vast amount of legal logic that went into the determination. And then the classification, you have to take a word string. We couldn't afford to download every document. It's 10 cents a page. Would kill you eventually if you're a startup. And so we had to take a very short string of text to figure out this is a Markman order. And then humans would cross-check it at the end of the day. We wouldn't assume we got the right answer. So there was a new language invented, which we called Legex. So it was looking at legal events in there, and we'd use that to determine it. And if the wrong legal words were in that docket event, it's a true error, right? If the court has decided this is a Markman order, we're not going to second guess that, right? So it was a non-narcissistic way to do it because it depended on what the clerk entered. The clerk had to make a determination about what this document was. We were just reflecting that in some ways. Did I answer your question?
Yeah, I wonder, so you are extracting different variables from the legal document.
Thank you so much. Yeah.
All of these different
Yeah.
characters and meanings, everything from the
Yeah, so you start with, this is this document, and then you have, what every document is in the case. That's really interesting, actually. That's called a graph, right? That's called an algorithm. A lawsuit is an algorithm for resolving a dispute. And if you know that, you can all of a sudden use all of computer science to help optimize those algorithms. Certain things led to settlements faster. Judges wanted to know that. This is what it is, NDCA or NDCal, right? So we did that, and then we looked at outcome probabilities. Win-loss on motions, and we had win-loss on motions, I think, in 2009. You could do kind of predictive modeling of this stuff. You could tell based on who the lawyers were, who the judge was, the district, venue. You pretty much had a good sense of who was going to win the case without knowing anything about the merits at all, because those things were heuristics for this. So there's a lot of heuristic, probabilistic data in there. You just can't trust it. But it never ends, right? The way I describe a legal document is it's an infinitely facetable fractal data object, because there's an infinite amount you can dig into these things. We had to focus on the things that the clients needed. Judiciary and judges were the main clients, right? I didn't care if we died as a corporate entity, but the judges, executive branch, Senate, we had some great Senate users as well, NASA, whoever. But those are the main users, but also the corporate and lawyer users, right? So this is what we needed. We focused on those. So, thank you. Other questions? Great. Thank you so much. I'm really